In this video, we will look at Section 101 of the Companies Act 2013, which deals with notice of meeting. As a real life example, we will take the case of Reliance Industries Limited, which is scheduled to have its AGM on the 24th of June 2021. We will also look at the rules which are prescribed under this section. Section 101 subsection 1 states that a general meeting of a company may be called by giving not less than 21 days notice, either in writing or by electronic means, as may be prescribed. It means as per the rules. We will look at the rules which will follow later on in this presentation. Of course, there's a proviso to this that a general meeting may be called after giving a shorter notice period if consent is given either in writing or by electronic means by not less than 95% of the members entitled to vote at such meeting. Section 101 subsection 2 states that every notice of a meeting shall specify the place, the date, the day, the hour of the meeting, and shall contain a statement of the business to be transacted at such meeting. So, Section 101, subsection 2 says that every notice shall have the place, date, day, and hour of a meeting, and of course, what business is going to be transacted at that meeting. Let's look at Reliance Industries Limited. On the 2nd of June 2021, it sent a notice to its members saying that after 21 days, that is on the 24th of June 2021, there will be the 44th annual general meeting of the company at 2 p.m. via video conference. Section 101 subsection 3 states that the notice of every meeting of the company shall be given to every member of the company. If he is deceased, then to his legal representatives. If he is insolvent, then to his assignee. The notice shall also be given to the auditors as well as to each director of the company. Section 101 subsection 4 states that in case of an accidental omission, very important, accidental omission to giving notice or non-receipt of such notice by any member who is entitled to receive such a notice of the meeting shall not be invalidated just because the notice has accidentally been omitted to be given. As I said, we look at the rules which are prescribed under this section, and the rules come from the company's Management and Administration Rules 2014. In particular, Rule 18 talks about the notice of the meeting. Rule 18 Subrule 1 states that a company may give notice through electronic means. Rule 18 Subrule 2 states that the notice can be through email, text, attachment to email, or a notification providing an electronic link or a URL for accessing such notice. Rule 18 Subrule 3.1 states that the email shall be addressed to the person entitled to receive such an email as per the records of the company or as provided by the depository. Rule 18 Subrule 3.2 states that the subject line in the email shall state the name of the company, the notice of the meeting, the place, and the date. So, Rule 18 Subrule 3.2 states that the subject line in the email shall state the name of the company, notice of the meeting, place, and date of the meeting. Again, let's look at Reliance Industries. We said that the subject line should contain what is the purpose of the meeting, the date of the meeting, that's the 24th of June 2021, the time of the meeting, 2 p.m. and also the person's name who is a member of the company, and therefore you will find his name on top along with his DPID, client ID. Rule 18, Subrule 3 states that if notice is sent in the form of a non-editable attachment to email, such attachment shall be in a PDF format or a non-editable format, together with link or instructions for recipient for downloading the relevant version of the software. Rule 18, Subrule 3.4 states that when notice is given by a company, the system which the company uses to send the notice should produce a confirmation of the total number of recipients made. Two, should record each of the recipients to whom the notice has been sent and a copy thereof, and any notice which has failed to reach the intended person, as well as its subsequent resending, and this system shall be held. This system will be used as a proof of sending the notice to the members. Rule 18, Subrule 3.5 states that the company's obligation shall be satisfied when it transmits the email, and it shall not be held responsible for failure of transmission beyond its control. Rule 18, Subrule 3.6 states that if a member is entitled to receive notice fails to provide or update his email address, then the company will not be in default for not delivering the message via email. Rule 18, Subrule 3.7 states that the company may send the email via an in-house facility or its registrar and transfer agent or any third party which provides bulk email facility. And finally, Rule 18, Subrule 3.8 states that the notice made available on electronic link or URL has to be readable, and the recipient should be able to obtain and retain copies. And the company shall give the complete URL or address of its website and full details on how to access the document or information. This concludes our video on the notice.